Welcome to Employee Termination Tips. My name is Christopher Neufeld of Neufeld Legal. And in this particular video, we're going to be discussing why some employers pay little or no severance pay and what this means. And to be clear from the outset, severance pay is distinct from termination pay in lieu of notice, where statutes in the jurisdiction prescribe the payment of termination pay in lieu of notice. And this is a prescribed amount of money that the statute and the government requires an employer to pay as a base minimum with specific determination terms. Severance pay, conversely, is a common law aspect and is above and beyond the amount that is required under termination pay in lieu of notice. So just because you've got paid termination pay in lieu of notice, you may well also be entitled to severance pay. But all too many employers, as I say, either pay little or no severance pay. And the main reason for that is because they know it is very imposing and difficult for an employee who has just lost their job to challenge it in the courts. Because one of the key things is you don't have the employment standards regime that's created by statute as a means to recover severance pay. Because as I alluded to previously, severance pay is not a creation of statute. It's a product of common law, judge-made law from the courts. And as such, it can only be attained through legal procedures before the courts. So if you have an issue that pertains to employment standards legislation, yes, you may pursue it with employment standards officer. But if it's something outside the ambit of the employment standards legislation, it is outside the realm of those employment standards officers and adjudicators to determine whether or not that additional money is owed. And employers know that. And as such, you have to go through an expensive and extensive legal proceeding that takes time and that costs money, or alternatively requires a lawyer who is knowledgeable in the practice and is prepared to operate on a contingency arrangement with the employee. Otherwise, the employers know that if you challenge them, they may pay one day, but they're not necessarily going to have to pay immediately. So what tends to happen, all too often, even if there's a demand letter sent out, the employers don't end up having to pay the full amount. And when they do, it's 1 in 10, 1 in 5, 1 in 100, where they actually have to go all the way to the day before the trial. Then they pay out their money. Meanwhile, the employee who is out of money maybe collects the same amount that they were due, maybe a bit more, maybe a bit less, but then the lawyers are taking the money. So when you run the math, this is a critical thing, when you run the math, if most people, if 8 out of 10, if 39 out of 40 decide not to pursue their employer for severance pay in the courts, or they challenge them for a bit, get some money, what is the economic benefit to the employer? It is going to be considerable because they have beaten back and they forced 39 out of 40, 9 out of 10, 8 out of 10, 97 out of 100 former employees who they fired or terminated to simply take what the statutory minimums are, maybe paid a bit more in severance pay, but not paid the full amount in severance pay. And what is someone like that to do if they realize that the imposition that's going to be put on them, the challenge before them, is going to be quite daunting? Well, the fact of the matter is that if an employer is willing to go and pay as little as possible in termination. There is a strong possibility that they've tried to cut corners and underpay the employee during the course of their employment. And even in the calculation of the termination pay, which is entirely possible. Because if you have a penny pinching employer who's always trying to undercut their employees, it's not going to simply be reflected on the termination arrangement when they choose to pay little or no severance pay. More often than not, those are the same employers who, if you look back at stuff, have attempted to find every possible way to undercut on other payments that are legitimately due to those employees. And I'm not saying that's going to be the case in every circumstance, but it's more likely than not that that is the type of employer that one is dealing with. If the employer, conversely, has put out a substantial severance package, there's either a stronger likelihood that they follow the law with respect to payments during the course of their employment, or the fact that they've put out this big severance package is going to make it not to one's benefit to challenge them as against the other aspects. So it's a balancing act then. But at the end of the day, you have to realize that as a fired or terminated employee, if all you're getting is termination pay in lieu of notice and maybe a little bit of severance pay or no severance pay at all, there are issues that need to be reviewed with a lawyer who's knowledgeable in this aspect. Because if this is the practice of the employer, it probably isn't limited to that one mere aspect. It might be. I'm not saying it might only be that thing. But it gives you a general perception as to how they approach employee pay and payroll and cost management. So when you come up against this kind of situation, that is when you need to take the time, you need to immediately address the situation and ascertain where you stand relative to your former employer. Because if there's money owing to yourself, if there's money due to yourself, and you're legally entitled to it, and it's not just going to be from the courts, but it's also going to be possibly from the legislation, it is your entitlement to pursue it because you're rightly deserving of it. And that is how you need to approach a situation where you realize after reviewing the documentation upon your termination that you're receiving little or no severance pay from that particular employer once you're fired from your job. Thank you.